Okay, good afternoon, everyone. I hope we're all here on Zoom for this webinar, which we're excited to make the presentation to you with regard to some very interesting issues related to AI, generative AI. This is being sponsored essentially by the Student Education and Admission to the Bar Committee, SEABC, as we call it. I am the vice chair. We have two great panelists here today, so let me introduce them a little bit. Arti Hirani is I hope I pronounced your last name right, Arti, but it was my best attempt. She is an estate planning lawyer who has been practicing in estate planning, international tax, and probate law, providing clients with tailored legal services for complex estate and tax matters. She received her undergraduate degree from the University of Florida. I'm a Florida State guy, and I know Jonathan is too. So, and my daughter's a Florida graduate, so we have a mixed family. And she also received her JD, excuse me, from Dwayne and Andreas Berry School of Law. She has represented a wide variety of clients, from soup to nuts, I will say, and has done she's a very skilled litigator. And I'm actually going off the AI version of your which is appropriate for this webinar, which is a great one that you did some tweaking to. She is the youngest president of the Orange County Bar Association, the first Indian American to hold that position. She's also the only OCBA president to retain her seat on the Young Lawyers Board in her circuit, as she's currently the president-elect of the Florida Bar Young Lawyers Division, YLD, the Board of Governors. She's also a past president of the Central Florida Association of Women Lawyers. She earned her executive MBA from the University of Chicago Booth School of Business in 2021, one of the country's top programs for executive education. And she also, as I take a breath, completed her LLM in international taxation from the University of Florida Frederick G. Levin College of Law. Welcome, Arti. Jonathan Grabb is the director of ethics, the Ethics and Advertising Department for the Florida Bar, which I'm very familiar with because I defend lawyers, and also I deal with issues related to ethics and advertising all the time. Before he became ethics counsel in November of 2021, Jonathan served the department for 8 years as an assistant ethics counsel, and he handled more than 20,000 calls on the ethics hotline. And he reviewed thousands of purported or proposed, advertisements, and issued dozens of staff opinions. He's a staff liaison, and this is important, to the Florida Bar's Board Review Committee on Professional Ethics, the Professional Ethics Committee, which I was on for many years, and the Standing Committee on Advertising. I was actually on that committee too. It's been a while though. He's also presented a variety of CLE presentations and published articles for the Florida Bar News, so look them up. They're really good, including the March 13th, 2023 article, Lawyers and AI, How Lawyers' Use of Artificial Intelligence Could Implicate the Rules of Professional Conduct. He's a cum laude graduate of Florida State University's College of Law. So that's about all I can say in one breath. Actually, it was kind of a breath and a half. Good job, Jonathan. So I'm Joe Corsmeier. I'm the vice chair of SEABC. I've been practicing since the mid-'80s. I was a criminal prosecutor for almost 4 years back in the '80s. I worked for the Florida Bar at the Tampa office for 8 years. I then left the Florida Bar and began representing lawyers who, I was prosecuting bar complaints at that time. I also, when I left the bar, I started defending lawyers, and some of my clients said, now you moved to, you have a white hat or something like that. They'd make a joke about it. It's like, well, okay. But also, I give ethics advice to many lawyers in law firms around the state of Florida and also around the country regarding multi-jurisdictional law practice. I'm hired and testify as an expert in legal malpractice, motions to disqualify, conflicts of interest, and things of that nature, including also fee disputes. And I'm currently a sole practitioner in Palm Harbor, Florida. So without further ado, hopefully I didn't take too much time on our schedule. Let's talk about the meat of our presentation. We're going to talk about a number of questions related to artificial intelligence. We're going to get up-to-date information regarding those issues. I'm going to first turn to Jonathan with regard to artificial intelligence, what it is, how we can make some sense out of it as practicing lawyers. And Jonathan's done a ton of research on this, so he's got a lot of good information related to AI and the current status of AI and how it is evolving. Jonathan, take it away.
Thank you so much. I appreciate the great introductions. And fair warning for those who are watching, if I have to go on mute, I'm recovering from a cold, so I may need to clear my throat or drink some tea or something at some point in the presentation, so please forgive me. So yeah, artificial intelligence as a general concept is not new. It's really anything that we create as a machine that is trying to mimic human intelligence. So yeah, your calculator, your smartphone, any of that is really a type of artificial intelligence. Now, of course, what the real big issue right now is generative AI, artificial intelligence programs that actually are creating something completely novel from limited input, basically that we provided. And rather than, again, having something that's a bit more formulaic, it's actually creating something, sort of completely from scratch, so to speak. Now, there are a couple types of AI, just to go through real quick, as a couple of concepts. So right now, and still, really everything that we do with AI is weak AI. And that's this concept of artificial intelligence that is not as powerful, really, that is not as complex as the human brain. Yes, my calculator can process mathematical equations much faster than I ever could. But that being said, it really can't take that complex information that I'm hearing, that I'm seeing, that I'm tasting, that I'm feeling at any given moment, and then process that into how we perceive and understand our environments around us. And if AI ever does get to that point, assuming that it does someday, that's what would be known as strong AI. AI that actually exceeds human intelligence, the human thinking capacity. We're not there yet. Even these generative AI programs, even though they can create images or video within seconds, they are not really strong AI. They do not have the capacity to fully understand and analyze and create new information, new stories in a way that the human brain can yet. So, to go back to generative AI, again, that's these programs that now are actually creating completely novel information, whether it's, text or images or video, audio, all of that is generative AI. And since the release of ChatGPT a couple of years ago, which, of course, that was really when a lot of this blew up in the public realm, is ChatGPT being released, it was primarily text-based, known as a large language model that you could put in a little, a request, write my bio for me, to write a motion to continue, give me a short story about, a kid who gets lost in the woods. And it could do those things. And, yes, it could generate that text from this very simple prompt. And that's really what I think caught a lot of people's attention because on some level, it actually seemed to understand context. In reality, these programs, even though they're very sophisticated, really are still predictive text in a lot of ways. They're still taking the information that they have in their databases, which is a vast store of information, in fairness, and they're taking that and distilling it then into these products that we see, these images, and again, in the case of ChatGPT when it was released, into other text. Now we're starting to see more and more access to what they call multimodal generative intelligence, where you can give it a prompt and it'll give you an image or a video. And again, these are not perfect. And so what I kind of find it akin to right now is sort of your microwave dinner. Like you can start a recipe from scratch and you can cook and create this great, excellent meal, that's healthy, that tastes great. And yeah, you can also go to the store and you can buy a pre-prepared meal that you toss in the microwave or toss in the oven. And yeah, it'll be, potentially fairly good. It will generally look pretty good. You might take a few bites in and find that the center's still cold. Like that's kind of the way AI is right now, is that, it's much quicker. It's going to give you this, pre-prepared, sort of quick generated result. But if you take a few bites in, the quality might not be fully there yet. You might still find that once you actually start digging into this, it's not giving you really what you need and really what you want to be consuming. So that's kind of what the way I think I would frame AI right now. Is it going to get better? I'm sure it will. How long will that take? Who knows?
Those are some great points. And you mentioned the vast stores of information that may be used for the for the AI that becomes strong. Copyright issues, we have lawsuits now where folks are suing these AI companies because they're using their name likeness, and also the information related to copyrighted materials to gather that strong AI, or at least the attempt to gain strong AI. So do you agree that that may be something that will prevent the ability to generate that vast store of information? It'll push back against that? Yeah, have you thought about that, or have you read about
Yeah,
that?
I mean, it's something that we'll really have to wait and see, I think, for a lot of these, because that litigation is still ongoing. Now, we
Yeah,
have had court decisions saying that an AI program can't hold a copyright and it can't hold a patent. Now,
points.
we also had similar sort of rationales, 120 or whatever years ago when it came to photography, that you had really, instead of painting a work from scratch, you just pointed and clicked and you got a picture. And there was a question at first about whether or not you could copyright those images when really they're the product of a machine. Well, clearly now, and really again, 120 years ago, we reached that conclusion that no, this is something that because of the human input is something you should be able to, as a creator, copyright. Now, whether or not, again, that's going to translate to these AI prompts, I guess we'll see. And on the other end of the process, again, if you're, say, looking at something that is heavily protected copyright, Calvin and Hobbes, Bill Watterson was notoriously protective of his copyrights.
Yes, he was.
At that point, yeah, is it something if you said, give me something in the style of Calvin and Hobbes, where that's a violation of his copyright interests? And we don't really know yet. We don't have an answer on that. And so, yeah, if that's what these are producing, yes, it's not going to be any exact image that's ever been created before, but using that style, is that still a violation of the copyright? And we just don't have those answers quite yet.
And also the vast stores of information that may affect the decision making of that strong AI as to what they're going to, I'll call it, spit out, provide us with. Arti, any thoughts on that? We're going to move on to a different topic, but if you had any thoughts, feel free.
No, I do think it's the land of the unknown right now, but as we're figuring it out, the rules are there to help us.
Absolutely. Good. That was a very interesting. Hopefully, y'all enjoyed that discussion. We're going to talk now about AI in practice. And Jonathan, I appreciate your overview. It was excellent. There's a Florida Bar Ethics opinion that y'all may be aware of. It may be part of the materials that were provided. It's Florida Bar Ethics opinion 224-1 that noted, quote, generative AI may have the potential to dramatically improve the efficiency of a lawyer's practice. So, Arti, I'll turn to you. What can lawyers use AI to do? And could you give us essentially an overview of using it as a technological tool and an example of drafting documents using this, what will is considered to be a vast improvement in lawyers' practice?
Absolutely. So technology changes between lawyer to lawyer. So I know some attorneys who still dictate to their secretaries and they don't want any use of technology whatsoever. And then there's other attorneys who use AI to do almost everything that they possibly can within the confines of the rules, I might add. So I personally love technology. I can't even stand to write something on a piece of paper. I need to type it to make sure that it feels known to me. But you can use AI to draft a bio like I did. You can use AI to draft will documents. So I do estate planning and probate. And so when I wanted to draft a will and a trust document, I used the AI generative software to do so. So I had it pull up the prompt. I told it what to do without putting any confidential information in. So I just added them to do a normal revocable trust. And it spit out almost a perfect revocable trust. I had to go in and fill in the names and the addresses, et cetera, the stuff that you couldn't put into the generative so it doesn't take the confidential information and regenerate it forward. It was missing the witnesses part, which is critical in Florida. It was missing the wrong type of promissory notes on the bottom of it because we put in warranty deeds, et cetera. And so there was big gaps. But I will say it did take away a lot of time that I would just have to do like cut, copy, paste, or completely retype something. So it was a good tool, and it wasn't that different from the software programs that a lot of estate planners used. So a lot of times there's programs that we could just type in our client information and it's within the confines of the software, so it doesn't give confidential information out. So a lot of estate planners will have their paralegals or their assistants put in those names and then edit the document afterwards.
That's excellent. The point you made about programs being potentially superseded by AI is probably giving these software companies shivers. I'm sure they've already gotten those shivers and maybe felt the effects of that. And also, I will point out that that's why lawyers are still important because when something gets spit out by AI, and I'll use that term, produced by AI, you as a lawyer had to look at it to make sure that tweak it or even maybe substantially change it if it's a more significant document. And I don't know, I mean, I'm not going to see it probably, but if we have AI superseding lawyers' services, I think I would be very surprised and very dismayed. So we'll see what happens in the future. Jonathan, as far as those topics, that topic is concerned, what about the Miami-Dade example that you have with regard to what's going on down in that area of Florida, and obviously it'll expand it to us, most likely to us or to the rest of the state of Florida.
Well, and to be clear, I certainly cannot take credit for this one. It's just an example that I've been told about because of my work for the bar. But yeah, Carlos Martinez, as the elected public defender down in Miami-Dade, he actually has really embraced this technology, and he found a great staff member who came from a clerk's office that had previously incorporated some of this technology into their software and their procedures, and basically found that for about, I think it was like around 40% of the filings that they received, they didn't even need to have human interaction to process those filings because of these software programs. And this is well before ChatGPT. This was in I think, 2017, 2018. So it's really before it was becoming, such a buzzword. And so, yeah, he's worked to incorporate this into his office structure now. And really, if you get the chance to hear Mr. Martinez ever talk about it, it's really fascinating. Because it does seem like it's something that, particularly for those who are early adopters, like Arti, where they're great at incorporating this technology, that, yeah, it can be something that really promotes efficiency as long as, again, you're fully aware of also the limitations of that software so that way you can make sure that you're not letting it, again, usurp your position as the lawyer. And I did just have one question, actually, if you don't mind, that I was going to ask Arti about. So was the software that you use specifically tailored to lawyers and legal practice?
Yes, it is. It's actually one that I had seen at convention. And so you type in the information and it spits out different types of trusts and wills that you need. But then again, you have to go through and edit the software as well. It spits it out into a Word document, and then you have to make several changes to it.
That's
Gotcha.
great.
Okay.
And I'll make a quick comment, and I'm familiar with this. Assistant public defenders are very, very busy. They've got a lot of cases. Of course, so do assistant state attorneys. So the fact that they could do 40% of their work without having a lawyer involved kind of is surprising to me. So I'm sure it's working out and they're supervising. Jonathan, any thoughts on that?
Yeah, I was just going to say, to be clear, it was the clerk's office could find that they could do 40% of their filings, but that she came from.
I knew that.
Yeah, that they could handle 40% of that. But yes, as lawyers, we still need to make sure that whatever we're submitting as a filing, you still have to click that button when you e-file to certify, yes, I have reviewed the contents of this filing. I can verify that they're accurate, both factually and based on the law. as well as that, there's not confidential information that isn't, disclosed in the filing, improperly redacted, all of those sort of things. You still, as a lawyer, are responsible, of course, for that content.
And I knew that. I just had a little moment there. Sorry. I knew that it was a clerk, but that's a far different story than having it done by lawyer. And of course, public defender's office can have AI to help them just like any other law firm, because that's truly what they are. And I think that's probably going to moving forward, that maybe there will be those offices moving towards assistance, maybe using AI. So, and there's nothing wrong with that at all. So now we're going to move to oversight, and you touched on it. I think both of y'all, Arti and Jonathan, talked about the lawyers. You were more recently, I think, Jonathan, the requirement that lawyers oversee any and all work product, including those that produced by the lawyer and those that produced by AI and that produced by non-lawyers. So it's important for lawyers to understand the ethical requirements with regard to use of AI and how to handle that, because as a tool, AI may be great, but if it's not used properly in the cases, and maybe Jonathan, you can mention these, there's some cases out there showing very clearly that lawyers didn't do their jobs. It's right in the in the cases, including hallucinations. Jonathan, real briefly, and then Arti will go to you. Can you give us an idea of an overall idea of the ethical, and you've touched on this a little bit, the ethical requirements for lawyers' use of AI, and also what in the heck hallucinations are?
Yeah, so hallucinations are essentially situations where AI, again, is functioning more, realistically, it's functioning more as predictive text and giving the sort of easiest or next answer sort of in the queue, rather than the one that is accurate for those circumstances. And this is something that a lot of these programs specifically tied to lawyers are trying to address by limiting actually the databases and allowing lawyers to input their own materials specifically into the databases. So I could say, hey, give me something in the style, a motion to dismiss in my style of writing. And it would be better at managing that, because it would actually be basing it off of my prior materials primarily, rather than, potentially looking off at somebody's blog that they've got on this issue in Colorado. And so, yeah, again, this is something that they're really working to address, because you've got cases where AI, in a sense, is a people pleaser. It's copying off of us and trying to figure out basically what we want to hear based on what we've already said. What's been put into these databases is, again, your blogs, your news articles, your novels, all this other material and content is being put in there. And so, yeah, it's not necessarily going to give you what's accurate for your circumstances. It's going to give you sort of, again, that predictive text response.
Right.
So that's really what these hallucinations are, is that it's giving you a response that may not be accurate. And yes, I'm sure everyone's heard the stories of the lawyers in New York in the Mata v. Avianca case, how they entirely got these fabricated cases and they submitted them to the court. And basically it was in part, it turns out, to cover up the fact that when the case got moved from state court to federal court, the state court lawyer who was handling the matter was not admitted in federal court. And rather than actually getting admitted or having the other lawyer who was admitted in federal court take over, they just had him ghostwrite everything without, actually verifying the contents. And so, yeah, when they found out that all of these citations were made up, instead of coming clean, they tried to cover it up because they were already worried about getting in trouble for all the other things that they were doing that were problematic, by having this state lawyer basically submit filings under the name of a lawyer who actually was admitted in that court. And of course, that's really when it blew up. And that's when it became a national headline. Yep. And you'd like to think that, people would learn from this, and that, it would only take one case before lawyers start realizing the limitations of this and how it could get them in trouble. And unfortunately, that's not the case. We had, again, in Colorado, we had Zachariah Crable, and hopefully I'm pronouncing his name right, but similar situation. He said, oh, no, it was an intern that gave me these cases. Sorry, I should have checked better. And no, really, it was generative text,
So-
one of these generative AI programs.
And so the cover-up's worse than the event, and also blaming somebody for it when it's actually so clear is that lawyer. I'm not going to say it out loud, but probably should have been severely sanctioned for that false statement. So thanks for that. Yes, Arti, excuse me. First of all, I want to say we've got a couple of questions, and also Katie Jones told me that we have a hand raised. If you could all put your questions in the chat, if we can get to them during the progress of this webinar, we'll try to. But we're setting aside 5 minutes for questions at the end, so hopefully we'll be able to answer those questions. If not during the during our webinar. I don't want to say too much either because I don't want to waste our time. So Arti, what about the rule requiring lawyers to supervise non-lawyers, and how would that apply? I know we talked a little bit about it, but what are your thoughts on that?
So actually, it came to my mind too when Jonathan was talking about the lawyer who blamed his assistant. So there is the rule 4-5.3 of the Florida Bar's Rule of Professional Conduct, and it covers the responsibilities of lawyers regarding non-lawyer assistants. So AI is new technology, but it's not really that new. We've had tools before, we've had assistants, we've had things that help us. It's just a different form of a tool, and we're extending the rules towards them. And I think it's important that we keep that in mind. And so the rule covers things like paralegals and legal assistants. And it basically states that lawyers with managerial authority to direct supervise authority over non-lawyers must ensure that the non-lawyer's conduct is compatible with the lawyer's professional. So even though you have these tools to help you draft or to help you complete things, the burden of complying with the ethics rules of maintaining your license still lies with the attorney themselves. So when I turn something into court, if I've had a paralegal, an assistant, if I've had AI and I've used AI properly, or even if I've used these software processes, I still risk my license if I don't look through them. I can't blame anyone else because I employed them. And unfortunately, the Florida Bar isn't going to come to a non-lawyer and say, listen, we're going to suspend your license, because they don't have a license to suspend. So they're going to come after me. And so when you use these people to help you in your practice, and, depending on your business model, they could be very helpful tools, but you have to remember that they are just that, tools. And so you need to supervise any AI, any type of drafting software, any type of assistant, any type of paralegal. There's cases all the times where lawyers get in trouble for just letting a paralegal take care of all their work. And as helpful as they are and as knowledgeable as they are, the buck still lies with the attorney.
That's great. That's great. And that lawyer, the blame the intern wasn't doing the right thing, was he? Or she? So just to kind of expand on that, the rule requires lawyers to take reasonable steps to ensure that non-lawyers, and actually they're supervising an associate lawyer, know the rules and are familiar with those, and know that what they are, as well as properly supervising the non-lawyer, and of course not blaming a non-lawyer for cases that were actually done by hallucination. And so, just real briefly, the rules presuppose that lawyers are going to take full responsibility for all work product. Excuse me, I'm the one coughing, Jonathan. For all work product related to court documents, documents that are provided to clients that are legal documents. So it's really important for lawyers to understand how that rule works, and how we lawyers are responsible, such as it is, much to our chagrin, maybe for some of us, that we are fully responsible for our work product and what we produce. That includes legal research. If a paralegal does research, if the paralegal uses AI and it's hallucinations in that legal research, then it's the lawyer's responsibility to find that out, not the court, if it's presented in a court document. So it's really important for people to understand how important it is. So if y'all don't mind, I was going to ask a question of the panel that we have on the chat, just because it relates to what we've been talking about. The first question is from Robert. If a client submits some information to an attorney's Gen AI interface, is that information protected by the attorney-client privilege / confidentiality? Because they go hand in hand. Privilege goes to litigation. Confidentiality includes everything. Likewise, is any output from that attorney's Gen AI tool also work product? So kind of even broader? Is it confidential? And then is it privileged and work product privileged in the context of litigation? Jonathan, let me start with you. Do you have any thoughts on that as far as whether there's confidentiality when under those circumstances?
So I got to admit, I'm not fully familiar with the case law on this to the extent that it exists right now. But that being said, my suspicion would be that if you're talking about a client in the first scenario submitting information through a generative AI, no, it's not going to be protected by attorney-client privilege because there is no attorney that is involved in that transaction. Now, on the other hand, if a lawyer actually is using it again, as Arti has indicated, as a tool and to help with their research, to help with their drafting, I imagine that almost certainly would be protected by attorney-client privilege, provided that, again, you're using a provider that is tailored to that purpose. Just like, again, with Westlaw, LexisNexis, any other research product, yeah, you should be able to use those without being concerned that even though it's a third-party software, it's accessible to the other side. So, I assume the courts would recognize that if you're using it for this research and drafting purpose, and again, Microsoft Word, that's a third-party product. I didn't develop Microsoft Word, but just because I'm using that software to draft documents doesn't mean that it's no longer protected by privilege. So I assume that would be the calculation.
I agree. Arti, anything to add that you'd like to add?
So I will note that certain AIs use that information to repopulate onto the World Wide Web. So I think it depends on the AI that you're using. So if you use it as a tool and you are confident in that it doesn't reuse that information to create better answers from more people, then yes, it can be seen as a tool. But if it's one that just repopulates, then I think you've broke the privilege and confidence yourself, which is also problematic.
Yeah, and sorry, Arti, that's an excellent point. If it's a self-learning software, it very well may use your input to then give to somebody else, in which case, yeah, you're probably right that it would no longer be privileged. So that's why, again, I would focus on making sure that whatever software you use is tailored to lawyers.
And of course, Robert asked another question. What if some of the output can later be identified as some permutation of publicly accessible or private database information that's subject to copyright? Do we all agree that that could be problematic? And I think I just mentioned that before as a question with regard to copyright and whether that's going to affect, would a lawyer be responsible or is the AI program? I mean, don't we have some very interesting legal questions here with regard to copyright?
Yeah, and again, I don't know that we have the answers to that. I mean, I think we're still waiting to see what the courts say about, in these copyright cases, that can that output potentially be a violation of another party's copyright interests? Exactly.
And then Robert had another question about a pro se litigant. What if they try to use GTP or GPT, excuse me, I got to get my acronyms correct, to search cases and statutes and then talk about those statutes at a hearing. Robert has heard that some courts have prohibited the in-trial consultation with legal gen AI. I would say that that's going to be a question of a fact or a case-by-case basis as to whether a court would allow that use of the AI. And so it's all going to be a matter of the judge, I think. What do y'all think? Arti?
I think it very much depends on the fact pattern and the judge. I will say, though, for lawyers, it's better to be safe than sorry. And so in these questions and the what ifs, if there's anything you can do to protect confidential information, just do it. It's not worth the what ifs.
I completely agree. What about these deep learning models that generate statistically probable outputs when prompted? That's straight from the ethics committee. Jonathan, you probably assisted in drafting that, didn't you?
Yeah, I was involved in the drafting process. The opinion was issued by the Florida Bar's Board of Governors in January of this year. And just a quick sort of shout out to that Board of Governors. It was the first of its kind, as far as we're aware, in the entire country. And so it really is something that is a significant achievement for the Florida Bar and for our members.
Good. Yes. And ethics opinion, we're going to talk about a little bit here. And what ethical rules surrounding confidentiality apply in the use of AI. We've talked about it already, in the context of privilege / confidentiality. Obviously, those, confidentiality, as we all know, encompasses everything related to a representation, and privilege relates to specifically to a litigation matter. Arti, I have a question. What about Ethics Opinion 12-3 regarding confidentiality, and how would you apply that ethics opinion with regard to confidentiality? Fire away.
So I know we've said this a few times, but it's just a new tool. It's a new toy for us to use. It's a new process for us to get more things done. We have had electronics for a very long time, and we've had cloud computing services for a really long time. There's already rules relating to how you use the disposition and maintenance of your electronics. There's already rules regarding clouds for your confidential. Oh, so sorry.
We lost you for a second, but it came back. You're good.
Thank you. So there's already rules regarding the storage of electronic data. You don't put confidential information in any way that it could be disseminated or it could be utilized by any other party. The rules of our profession have not changed, and they will not change. We are here to protect our clients. We're here to do a good job, and we're here to promote and serve. And in that capacity, you have to maintain confidential information. There's going to be a new tool. There's going to be a new toy. There's going to be a new electronic service in the next 5 to 6 years. And our duties and what we're supposed to do as lawyers aren't going to change. If anything, they're going to broader encompass. And the buck always falls to the attorney, because we're supposedly the ones who are to help other people. You can't ever use that to injure another party. And that's just the way our profession is created. So there are ethics opinion on the disposition of materials and maintaining those. And you just safeguard those and use the same ethics rules and provide it to this tool, which is AI. And in maybe a year or two, what the next tool is going to be.
Right, the next big thing. So, Jonathan, I would say that maybe this is changing a little bit, but many lawyers are not familiar with AI and the issues related to AI. What are your thoughts on the bar rule? Again, I know we've talked about this a little bit, but you could maybe expand on the bar rule and what it requires, and also and I said this already. I took your thunder. Sorry, that the difference between confidentiality and privilege and as it relates to AI. And also open databases. What are your thoughts on that?
Sure. Yeah. And the duty of confidentiality is a foundational principle of lawyers as applied in the United States. I mean, this is something that is not new. And Arti's right. There really haven't been significant changes in the rules, in those obligations for many, many years. And part of what you need to keep in mind as a lawyer, yes, confidentiality is distinct from attorney-client privilege. It applies to everything you learn in the course of your representation of a client under Rule 4-1.6, Florida's rule for confidentiality. And yeah, so it's much broader than privilege. Now, it's not going to be the basis for an objection in court like attorney-client privilege would be. But for you as the lawyer, unless one of those exceptions in the rule applies, you should not be disclosing any client information, even if it's available through, public records to third parties. And so that's really what the rule is focused on. Now, there is also a provision, I believe it's sub D of 4-1.6, that notes that as lawyers, we have an obligation to take reasonable precautions, take reasonable measures to assure that the information we have is protected from inadvertent or malicious disclosure, or access by others. And so when you're talking about, as Arti noted in 12-3 for cloud computing, and as noted in 24-1, which actually cites to 12-3 a lot, part of that in these instances means assuring that this third party that you're working with has some enforceable obligation to actually keep that information secure. And they, yes, they also have a duty then to notify you, say, if there is, inadvertent or malicious access to the information that you've submitted. And so again, that reiterates why you want to go with a reputable provider that is targeted to lawyers. Because when you're talking about, just ChatGPT generally, No, it's not built for lawyers. It's built for the public. It could be self-learning to some degree. Some of these programs could, in which case then they're giving your information or really your client's information out to third parties and their questions and queries. And so that definitely is a problem. But even if they're not using it for self-learning, a lot of these programs actually store the information for a certain period of time regardless. So that's actually something that lawyers need to be aware about, not just for generative AI, but you go to a printing processor, you go to Kinko's, you go to, a UPS office or FedEx, and you ask them to make copies or print something out for you. They very well may be storing that information on their hardware. And you probably want to look at their policies because depending on the content of that information, they may even use it then for marketing or to sell that information and data off to third parties. So again, that's really what lawyers need to be aware of is just like Arti noted, this is another tool. And that's all it is, for at least for now, and for the indefinite future, as far as I can tell, this is something that is a tool for lawyers that we need to understand and know how to use safely in a way that we're still protecting our clients' information.
Excellent. And I would encourage everybody on the call here, on the webinar here, to read 12-3 and 24-1, because 12-3, I was actually I was on the professional ethics committee when we discussed that. It was an interesting discussion, but it's really important because it lays down important concepts for lawyers regarding the potential dissemination of information that we don't want to let happen, and also protections. Nothing's perfect. We all know there can be a hack or whatever, but using these programs, we don't want the programs to, or the companies that create the programs to use information contrary to confidential information improperly. So it's up to us to make sure and take steps. So I would read both of those opinions. They're really important. And also, as Jonathan and Arti said, 4-1.6 confidentiality. It applies. It's going to apply unless something weird happens. It's going to apply to everything we lawyers do, and it's important to keep up on this. AI is ever evolving, right, Jonathan and Arti? It's ever evolving. So we have a duty as lawyers to maintain our competence, and that includes technology. And the rule itself, y'all can confirm this, it requires us to maintain our competence in technology. Arguably, to have someone who's familiar, a third party must be aware of that, of the confidentiality and the other bar rule issues. It's our duty as lawyers, and that was put into the rule, into the comment. We're required to maintain confidentiality with regard to all technological or technical, technical competence technology. So I'll emphasize that, because that's, if you remember anything from here, it's important to know that we have the duty to maintain our competence, and this is another technology. It's been talked about for a long time, as Jonathan and Arti, I think, both said, but it is here. It's weak. I don't know of anybody that's saying, maybe there is somebody saying they have strong AI, but as far as that would be like us, think like us, which scares the heck out of me. I don't know about y'all, but us thinking like us, really kind of scares me a little bit. And maybe it's just because of my age, but maybe not. That was really good, a very good discussion. I have another question, actually kind of a comment from Robert, which is good. Take a look at the chat, y'all. A show cause order issued to pro se litigant whose court filings were drafted by Chat GTP, and the court suspected a ghostwriting anonymous attorney writing or drafting the filings. There's a link there from Robert, so I'd encourage y'all to take a look at that. So we're pretty close to the 5-minute questions. We've already gotten questions on the chat. So what I'll do is we have a final pretty interesting topic. It's 12:44, so we have a few minutes to talk about this, and then we can. And if y'all have any questions, you can put them on the chat or raise your hand, and Katie will be able to see your hand being raised. But the last topic that we thought would be interesting to talk about is the issue of lawyers billing and the fees issue with Chat GPT, or chat, let's just call it AI. With AI assisting lawyers and maybe improving the time in a good way, like shortening the time drastically that it takes to perform a certain task from the old days when we didn't have that. do lawyers address the issue of billing and whether, whether hourly billing would even be viable at this point? I'm going to start with Jonathan, and then Arti, you can pitch in too. What are your thoughts on that, Jonathan, if I might ask?
Yeah, so actually, I know Arti had some information she wanted to provide on this one, particularly regarding the ABA standards.
That's right.
And
Sorry, Arti. You want to let her go first? But go ahead,
No,
Jonathan.
yeah,
I'm
if
sorry.
that's okay.
My bad. You want to go first, Arti, and then we'll go to Jonathan?
absolutely. So Jonathan has more pertinent information regarding the Florida rules, but I was going to talk about the ABA Model Rules of Professional Conduct Model Rule 1.5 on fees. And it requires lawyers' fees and expenses to be reasonable and includes criteria for evaluating whether a fee or expense is reasonable. So if you are using AI and you spend 15 minutes putting the relevant information into the program, you're allowed to charge for it by the ABA rules. And in most circumstances, the lawyer cannot charge a client for learning how to work an AI tool. And so, again, just like we've discussed, using it like a tool. So if you use a tool and you're reasonably billing in that circumstance, you can charge your client for the time spent, but not for learning how to work Word. You would never charge your client for that. So you shouldn't charge your client for how you work AI or ChatGPT.
That's an excellent point, because we all know, and there are ethics opinions that talk about this, we can't charge our client if we're not proficient in an area of practice to get up to speed, unless we tell the client, hey, I'm not proficient, I need to get up to speed. Are you okay with that? It's always about client permission. So if lawyers saying, spending time researching or learning about AI, I don't think that would fly, right, Jonathan? Any other comments?
Yeah, Arti makes some excellent points there that yes, to maintain competence and to perform those sort of overhead tasks, that's not really something you should be billing a client for. Now, on the other hand, Florida does have some distinctions from the ABA model rules in that the ABA does not permit a flat fee that is non-refundable at the start of the representation, while Florida actually does. And this is something that, again, is addressed a bit in 24-1. But I think this is really going to be one of those tools in Florida that's going to help lawyers to manage practice if, assuming AI does make us that much more efficient. No, you can't bill for time that it would have taken if you didn't have AI. That is falsely inflated billing. That is a problem that's going to be prohibited. You can charge the actual cost incurred of using an AI program, just like you could charge the actual cost for that individual client for another research tool. But again, it has to be tied to the actual cost for that specific client, not just you, generally using those resources. Now, I think the reason that it's going to be important here in Florida, again, to have that is that, yeah, we're going to have situations where AI may make something so much more efficient that really the lawyer's primary function is to make sure that what the AI gives this person and what it gives us as lawyers is accurate and is actually, going to recite the facts and the law in a way that is not just accurate, but also it's going to be persuasive. That is, again, a big part of our role. And so, that's going to take knowledge of the individual, judge, of the individual parties involved, to make sure that your client is satisfied. So again, there's a lot more nuance, I feel like, that, lawyers can still have in that process. But if, say, AI does something in 15 minutes that would have taken you 2 or 3 hours, yeah, if you're billing hourly, you can only bill 15 minutes. On the other hand, if you say, I handle divorce cases for, $10,000 under these circumstances, and that is my flat fee that is non-refundable, in Florida, you can set that arrangement in writing, and if the client signs it and agrees to it, and then they say, 2 weeks later, they come back and say, well, I could have done this. I could have just put this into an AI program. Why do I have to pay you? Well, hey, you already paid me. And you agreed that this, to this fee at the start of the representation, it was reasonable under the circumstances. It prevented me from taking on other clients in this same matter. So yeah, I get to keep the $10,000 that you paid me. And I'm sorry that you think that you could have done just as well with AI. But no, that is what I'm here for as the lawyer. This is the process that I, navigate and that I'm trained in.
And you're absolutely right. And the ethics opinion states that the lawyer must do enough work to where it justifies keeping the money. And you'll read that in the opinion. what's the number again, Jonathan? I mentioned it before we got on. The
Oh,
ethics.
93-2, is that the one?
93-2. Thank you. I don't know why I was
Yes.
having thank you for your young mind. So it's important for lawyers to understand, and I would take a look at that opinion, because if you're going to charge a set fee, you want to make sure that you follow the guidelines within that ethics opinion, which mean that not every non-refundable fee is going to be, the lawyer can keep it. And the bar takes the position that if the lawyer didn't do substantial work, or to give an instance, if the client says, I'm firing you the next day, and the lawyer hasn't done any work on it, that's going to be excessive if the lawyer wants to keep it. So I'll just kind of round out what Jonathan talked about. It's really important. And also I'll just point out that task-based billing is a thing, and lawyers can bill per task. And it could be a set amount, a non-refundable set amount to do this for you. That, I think, is something that lawyers should consider, because a task-based billing would then be, I'm going to break it down, and this is what I'm going to, and it wouldn't matter how long it takes the lawyer to do the work. And the fact that the AI is available, the lawyer still has to supervise the use of AI and make sure that it's proper work product. So the lawyer is vital. The lawyer's services are vital in that. So I think we could kind of talk about evolving that. And obviously it's brand new, and we're still talking about this. So a couple things I'll mention. There's been some questions about which legal gen AI programs seem the most compatible with maintaining confidentiality. I have no idea. Anybody have any ideas? I usually don't
just go with ones that are from providers that are used to working with lawyers is what I would focus on. Again, your reputable providers, LexisNexis, Westlaw, that sort of thing.
Like Arti said, she's the one she uses. She did some research, or the firm did. Also, Chardine Hill, who I know well, asked Jonathan, if the AI program cost to say $99 a year, how is that not overhead for the firm versus being charged to the client for the use of that service? Trying to make sure I did not misunderstand what you just said about charging the client for the cost of using AI services. So that Chardine has that question. Did you want to comment on that? And
yeah, please. That's exactly right. If it's a flat fee that the firm is being charged for a time period or for use of the service just more generally, then no, you should not bill that to any individual clients. You should count that as your overhead, whether it's $99 or $9,999. If that's something that you can't attribute to a specific client for that cost, then you should treat it as overhead. And yeah, if you need to raise your hourly billing or your flat fees to acknowledge that additional overhead, then that's how you would accommodate that. On the other hand, I don't know how common it is these days, but I know, Westlaw used to be, at least, where you would put in the client name. This is who I'm actually working for as I'm doing this research. And then Westlaw would give you a specific bill for the work that you performed related to that particular client's matter. And so in a situation... Sorry?
Yeah, go ahead. Sorry. LexisNexis does that too. Go ahead. That's right. Really good point. Keep going. Sorry.
And so just like that, when you're talking about generative AI programs, if the software has some mechanism where you can say, hey, client, this is what was specifically incurred for your interest, for your research in your matter, then, yes, then you could pass it along because you can show what specific client it was for. And of course, it still has to be reasonable under the circumstances. And attributable again to that specific client. You can't just say, hey, I did some work for Joe last week, but I really want to learn more about this issue. I'm just going to put Joe as the client because it's kind of related to his work. So yeah, let me just put Joe's name in there. Of course, you shouldn't be doing anything like that
because that's fraudulent. But also, the overhead is discussed in some ethics opinions, which numbers I don't remember. What is overhead, what's not. Clerical work is overhead. You don't charge lawyers, and I'll tell you, I've got a lot of people on this. The bar does not approve charging a fee to open a file up, a file opening fee. Few of my clients have learned that the hard way. So I would encourage all the lawyers not to charge a fee to set up a file, but also clerical work is all going to be overhead. Paralegal, or even if a paralegal gives directions to the courthouse, that's going to be it's going to be clerical. But if a paralegal summarizes, it's kind of the distinction between does it move the ball forward on the client's case versus is it just something routine that does not? And so that's how I describe it when I talk about it in webinars. And Jardine, you're absolutely right. There's the lawyer can't charge, even if it's a portion. I've also had a client who charged $200 or $100, whatever the number was, for telephone calls. This was a few years ago when we were actually being charged more for phone. And she was looked at by the Florida bar for a whole nother reason. And the bar said, you're not allowed to just charge this certain, and the argument was, that's about what the clients, and it failed, but luckily the lawyer learned a lesson. This was a young lawyer. So we're not allowed to take for instance, a telephone bill, and not even ignore a telephone bill and just charge a client a certain amount, for instance, for a telephone call. So I'll leave you at that. I think we're pretty close, if not already. I know y'all have busy schedules. I think we're right at the time that yes, we are. We're right at the time we were going to go to. And I want to thank all of you for listening to us. I think Jonathan and Arti did a fantastic job. I really appreciate, and we really appreciate their participation. I do have a new message. Let me see if we have a message here. Oh, thank you, Katie. Katie gave us the information. Thank you so much. The CLE number is 8809. You can go get your hour of credit for the CLE, but hopefully you've learned a lot from the CLE, because we've enjoyed making the presentation. I thank again, Arti and Jonathan. I thank you again for taking the time to participate in this webinar, and we wish you all a very great afternoon and best wishes in your futures. You take care.
Thank you so much.
Yes, and also look at these the links that Katie put on there. If you want to open those up before we get off, and you probably already have if you wanted to look at it. Those are some really important links. And I now have new messages. So since we're on, thank you everybody. Thank you everybody that said great job. We really appreciate your participation. You're listening to us, and we hope you gained a lot of information. So I guess we can now finish up, and I guess Katie will be the one, and I guess we can go ahead and sign off, y'all. Thanks again for being on this webinar. Everybody have a great day.